gentlemen, esteemed guests, respected faculty members, and dear students, I am Kirti Anand, President of the Legal Aid Clinic, and alongside me is Swati Gadi, Vice President of the clinic. On behalf of Vaarta International Business School, it is our immense privilege to welcome you all to today's Vaarta interactive session on the theme Strengthening Access to Justice Through Legal Aid, Innovations, Challenges and the Role of Law Students. Before moving ahead, let me introduce you to Vaarta International Business School. Established in 2004, GIBS is affiliated with Guru Gobind Singh University, Delhi, and is approved by All India Council for Technical Education and the Bar Council of India for its law programs. The institute offers a diverse portfolio of programs including MBA, MBA International Business, MBA Integrated and BBA Honours, Integrated BA LLB Honours, BBA LLB Honours and LLM. GIBS has consistently been recognized for academic excellence, accredited with an A grade by NAAC in its third cycle, rated A+ by the State Fee Regulatory Committee under the NCT of Delhi, awarded the highest rating of A by the Joint Inspection Committee of the Government of NCT of Delhi and GJ's IQ since 2013. Rated grade A by the Academic Audit Cell of GJ's IQ since 2011. Beyond academics, GIBS provides a vibrant learning environment that nurtures critical thinking, leadership skills and a sense of responsibility among its students. The Legal Aid Clinic of GIBS, under which today's session is organized, stands as a testament to this vision, working to bridge the gap between law and society by empowering students to serve communities in need. We are deeply honored to have with us two eminent academicians and legal scholars who have made remarkable contributions to the legal education and the cause of justice. Dr. Ajay Sonawane serves as Assistant Professor, Senior Scale at Law Center 2, Faculty of Law, University of Delhi. A gold medalist in Law of Contracts during his LLM, he completed his BSL, LLM and PhD from Savitribai Phule, Pune University. His areas of expertise include human rights, law, administrative law, public international law and jurisprudence. He has presented papers at numerous national and international conferences, contributed to research projects under the Ministry of Women and Child Development and Ministry of Tribal Affairs, and co-directed international mediation conferences in collaboration with the Supreme Court of India. In addition, Dr. Sonawane has held several key administrative assignments at the Faculty of Law, University of Delhi. He has served as a member of the Legal Aid Committee, member of Committee for Integrating the Spirit of New Education Policy 2020, and member of Course Committee of Delhi School of Public Policy and Governance. He has also been a resource person in national and international seminars and webinars, including sessions organized by NHRC, Press Information Bureau, Government of India and other prestigious institutions. Dr. Ajay is an Assistant Professor at the Faculty of Law, University of Delhi Law Center 2. He holds a BSc from Himachal Pradesh University and pursued LLB, LLM and PhD from Punjab University, Chandigarh, along with a postdoctoral fellowship at the Mediterranean International Center for Human Rights. With teaching experience since 2005, including at Lovely Professional University and Delhi University, his areas of specialization include constitutional law, property law, the Civil Procedure Code, and the Limitation Act. He has presented papers at national and international forums, published widely in reputed journals, and continues to contribute actively to legal academia and research. To formally honor our guests, I request our respected Sonia ma'am to present a green token of gratitude to Dr. Ajay Sonawane and Dr. Ajay Kumar.
Am I audible? Yes. So, respected Sonia ma'am and my dear colleague Ajay, so very good morning. Today we are here to interact with you on the topic access to justice and we will try to learn from your side also. Not only that, but experience we have, we also try to learn from your side also. So before starting, that we will try to highlight the introduction of the topic access to justice. So as all of you know that justice word is used before the access. So how we can access to the justice? So all of you comfortable with English? If someone is not comfortable, we can also try to use both, because if you are able to interact, then we can able to achieve the targets of this program also. So access to justice is very, very important right. Without this right, all other rights are not of any value. I think all of you agree that access to justice is very, very important right. So before highlighting the meaning or importance of access to justice, we will try to highlight where our constitution stands with the access to justice. All of you know that what is supreme in India? What is supreme in India? Constitution of India. So first I will try to highlight that what is the stand of our constitution with access to justice. So if we try to connect with Constitution of India, then which document we are supposed to connect? So preamble is the very first document or area or place of our constitution which we can connect with access to justice. So in preamble it is written that we the people of India, we the people of India. So we the people of India having solemnly resolved to constitute what type of India? Sovereign, socialist, secular, democratic republic. So what type of India we want to constitute and what type of objectives we want to achieve. So what type of objective we want to achieve? That is the first is justice. Justice, what type of justice? Social, economic and political. So justice word is used. So what type of justice we are achieving through socialist, secular, democratic republic India? That is justice. So first justice, or what we can say social word is used with the term justice. So social justice, then economic justice, political justice. Then we will try to connect the word access also with the justice. So before starting that, let me complete the preamble. So justice, then liberty, then equality, then fraternity. So these things we are going to achieve through the preamble. So while we are going to achieve these objectives, role of paralegal volunteers is also very, very important. So in preamble, it is the duty of everyone to achieve the justice. Many times the question comes that is it the duty of only PLVs? No, it is the duty of the justice. How we can achieve the justice? Through constitution. Then there is a part 3 and part 4 is very, very important part. So part 4 give us hint that India is a welfare state. India is a welfare state. So preamble and specifically article 38, promotion of social order. Then new article added 39A. So we will try to connect these provisions so that we can come to clear that our constitution gives clear mandate that there must be justice, not only civil and political but also social. As all of you know that Dr. B.R. Ambedkar ji also said that economic justice, social justice is more important than political justice. So then while we are going through the access to justice, now time is not only access to justice, now time is to quality of justice. Quality of justice. Today we are availing various type of services. We are also trying to choose those type of services which have more quality. Now time is it is a time of skill oriented. So our duty or our target should be how we can play a role so that we can provide that type of justice which is the demand of time. Interaction I will try to highlight access to justice, then rule of law. As all of you know that rule of law is the basic feature of our constitution. Then through rule of law we will also try to connect with the Constitution of India. Then these 3 articles are very, very important. Though whole the constitution is important, But for this interaction, Article 14, 21, 39 is very important. Then I will try to conclude the interaction. So can you move the next slide? So now access to justice is a basic right. If there is no access to justice, then other rights are of no value. So access to justice means how we can access the courts, how we can get remedies, how we can defend our rights. So access to justice plays very important role. And all of you know that all are equal in the eyes of law, but not in the eyes of court. Some advocate take huge fees, some advocate not able to get the client. So what is the role of PLB in this stage? As all of you knew that in hospitals, the person who is at the first entrance, the person who is dealing at OPD, he plays very important roles. Similarly, PLB will play the role at the entrance level. If they are able to identify the problem, then they will guide how the access to justice, how the remedies can be availed. So your role as a PLB is very important because legal field is different from other fields. Can anyone suggest what is the difference between legal field and medical field or other science field? In the legal field, there can be two answers. But in science field, there is only one answer. So role of PLB is here very important because you will play the role at the entrance level. So at the entrance, if you are able to identify the problem, then you can easily guide that person how relief can be taken through the courts or from the authorities. So at this stage, access to justice is a basic right. So please let me very clear, as a PLB your role is very important. How you can ensure that, how you can provide the help to those who require your help in the field of law, how they can get access to justice. So here rule of law is already there. But how we can connect with the rule of law? So PLB is a bridge between a gap between those who have no access to justice. How you can provide that? There is a different mechanism, but rule of law now also leads to the rule of law. Then we will also discuss that quality of justice, access to justice with quality of justice also. So access to justice is also a fundamental aspect or pillar of the rule of law. So the rule of law is also of no value unless there is access to justice, unless there is a reach of everyone whose rights or liberties are violated, they can approach the courts. So now I will try to connect some basic provisions of some laws or constitution which deal with access to justice. So every one of you know that Article 14 deals with equality before law. So state every person is equal before the law or equal protection of law within the territory of India. So this article also says that equality before law or equal protection of laws within the territory. Now this article 14 use the word person. It is available to person. So person is a broader term. It is not only confined to citizens. So everyone is entitled to equality before the law. So Article 14 is also a rule of law. So Article 14, then Article 21, it says that state shall not deny to any person right to life or personal liberty. Right to life or personal, except procedure established by law. Now after Maneka Gandhi, procedure established by law becomes a due process of law, just, fair and reasonable. Now when we connecting Article 14, 21, 19, now they are overlapping or strengthening each other. Now it becomes a golden triangle. So now equality before law. How we can ensure equality before law when someone is represented by a good lawyer? You can name any good lawyer. There in India they are earning huge money, and someone is not represented by someone. एक के हाथ में आप गन दे देते हैं, एक के हाथ में आप स्टिक दे देते हैं. Where is the equality before law? एक के पास कोई एडवोकेट नहीं है, एक के पास जो है वो गुड लॉयर है. So it is also the violation of Article 14.
So how we can ensure equality before law, equality of arms, equality of platforms? So Article 14, 19, 21, and Supreme Court interpreted that legal aid is also a fundamental right. So no one can be deprived of legal aid. If no legal aid, then there is a violation of fundamental right also. So after this, all of you knew that public interest litigation is very famous in India. It is also helping to provide justice or access to those who have no access to justice. So what is the full form of PIL? But sometimes it becomes paisa income litigation. Sometimes it becomes popularity, private income litigations. So there is a gap between how we are using these platforms. So how we can ensure PLB plays the greater role than how we can maintain balance so that everyone can get the justice. Because if justice is not provided, then society cannot achieve the objective through the constitution. Then all of you knew that in CRPC, now it is a BNSS. There is earlier section 133, now it is section 152, public nuisance. While you study the environment law, then you will find various. Here you will also get the platform where we can redress the problem of society. Then in CPC order 33, order 44. Then in CRPC, there is a 304 and now BNSS section 341. If legal aid is not provided, then that decision can be challenged and court can set aside. If accused, when court conducted the trial without providing the legal aid, then it has a serious consequences. So now it is a time to correct constitution, then other laws which plays a greater role than how we can provide access to justice. So there are various laws which help us to achieve access to justice as a fundamental right. Please next. Then right to life, everyone knows that 21. Then 39 is very important article for us because it is added by 42nd amendment. It deals with 39 is very relevant for the PLBs, equal justice and free legal aid. While if you interpret 39A, here it is written that legislature by or parliament by suitable legislation make law which help to achieve access to justice or which help the implementation of right to legal aid. Parliament under this article made the Legal Services Authorities Act, which sir will discuss with you. That is very relevant law for our role as a PLB. So article 39A is very important for us, how Legal Service Authority is enacted from where Parliament gets the power. After this, there are various cases, but some cases are very landmark. As a PLB, you are supposed to know to Sonawane Khatun, then Khatri, then MX household. Here, legal aid is held to be fundamental right. It is a part of 14, then it is a part of 21. Then we are saying just, fair and reasonable. So free legal aid is also comes within the part 3rd. So these are some cases we can also connect with the interpretation of Supreme Court. So social justice, all of you know that social justice term is used from where we are getting from preamble. So social justice to access to justice. How we can say India is having objective of social justice because part 4 directive principles, welfare state. How we can say that India is a welfare state because preamble and part 4 is saying. And what is the main target of welfare state? Human dignity. So how we can ensure the human dignity? If someone is not getting the rights or access to courts, where is the dignity? So access to justice helps us to achieve the objective of a welfare state. So access to justice and social justice are connected. Then please next. So now I will try to conclude these PPTs that equality before law, equal protection of law, or right to life or personal liberty. These can be realized or we can enjoy these protection if there is a effective access to justice. Effective access to justice. If someone has not access to justice, these rights will be equal to the zero. These rights have no importance, these are just formalities. As it is said that if you have a purse but no money, आपके पास पर्स है लेकिन पैसा नहीं है तो वही बात है. Access to justice, realize other rights. Then this is already I discussed that National Commission to Review Working of Constitution NC RWC recommended that there must be Article 30A in Constitution which specifically deals with access to justice as a fundamental right. Then it is already said that everybody is equal in the eyes of law but not in the eyes of court. Some there is a face value, there are various differentiations. So as a PLB, we must ensure that how we can contribute to the societies. Because if we have not enough money but we have knowledge so that we can guide, so that we can achieve the constitutional objective which is the main duty of the PLB and as a mission of legal aid. Then it is also required that every student, not only those who are PLBs but one who is law student, they have to take pledge that how we can contribute, how we can provide free legal aid to those who require the legal aid. Then rule of law to rule of law is very important now. Everything is written in the books, we study everything, but whether we are applying those at the society level or not. So role is more important rather than what is written in the books. So legal aid is a legal necessity at this time. So various programs from the various societies or institutions or authorities, why they are launching those programs? If someone is not getting the legal aid, is not access to courts, then what is the relevancy for that person of fundamental rights or directive principle? So these are the some points. So please try to connect your access to justice with your constitution, then with your rule of law, then as a citizen of India, as a law student, how I am contributing to the legal aid, how I am contributing to the objective of the Constitution of India. If we are able to connect these things, definitely we are able to provide legal aid for those who require it most. With these I try to conclude. Thanks for listening.
Now I would like to invite Dr. Ajay Sonawane to share his thoughts.
Member of Legal Aid Society or as a student of law. So once you understand the purpose of the same, once you understand what need that we have as a part of the society, so then there itself then we can start working on it. Because as you know that I think your goal is also the work is worship. So that work is worship is not only for the purpose that you are obviously to earn the money, but apart from that, the true justice also should be delivered to the needy people or wherever it is required. So here, access to justice is having its constitutional value because it is not only a fundamental right, but it is somewhere basic or it is just or a reasonable right, wherein every individual is entitled to have it. Because when we talk about legal aid, this word legal aid, so what do you think? Like if I ask you, as it is an interactive session, so I can take some liberty to ask you something. So if I say that it is when we use the word legal aid, so what do you mean by legal aid? Whether it is a fundamental right, whether it is a constitutional right, whether it is a legal right, what is your opinion about legal aid? आपको क्या लगता है legal aid क्या हो सकता है? What is the meaning of this term legal aid? What category of this right is all about? Whether it is a fundamental right or whether it is legal right or the constitutional right. What do you think? Legal aid, कानूनी सहायता हिंदी में अगर पूछे जाए. So what do you think? Whether it is a fundamental right? Fundamental. Or legal right or constitutional right? What do you think? क्या लगता है आपको? आप सारे are they from first year or second year, third year? अच्छा ठीक. First year. So this is I think basic question. Legal aid. ठीक है. So what do you think? What category of right it is? Legal right. It is of what category of right? Whether it is a fundamental right or whether it is a legal right. Fundamental right. Okay. If I take it as a fundamental right, I mean सही गलत कोई दिक्कत नहीं, आप बस कंट्रीब्यूट कीजिएगा. So if it is a fundamental right, then we just have to understand one important point here is that when we talk about legal aid as a fundamental right, then the understanding will come that every individual should have access of this legal aid, right? As an individual, everyone is eligible to get the access of this legal aid. But here, when you refer this Legal Service Authority Act that we will see here, the term legal aid here which is used is for the person who is entitled to have that legal aid. So the word which is attached to the person of which nature, the person who is entitled to have a legal aid. So the entitlement is something which we have to focus upon. Entitlement का मतलब क्या हो गया? The person who is entitled, the person who is eligible, the person who is having that right to ask for the legal aid, which is of free nature, which is the free, which is without any paying money, without any paying any kind of money or any kind of financial liability. So when you talk about free legal aid, the free legal aid concept is available to whom? Who is entitled to have that free legal aid and further advice and all the further procedures that is expected under the Legal Service Authority Act. So here access to justice, when we refer this term, so the justice is what category of justice? As we have heard that in the preamble, we have a social, economic, political justice. So broadly we know that these are the type of justice. But ultimately when we talk about justice, then it may be the satisfaction also, like if there is a victim, right? If the victim has suffered some kind of injury, some kind of loss, some kind of violation. So whether justice delivery system, that is judiciary का जो judgment होगा, whether that is actually a justice or simply knowing something, simply if someone listens to you, even you feel better. So even that probably a person in that scenario also that person may feel better. So ultimately justice is not always a justice that is delivered by some judge or that is delivered by some courts, but justice is also to heal someone with the solution, with the probability to listen to someone and also give some kind of solution. And there the role of law students comes, or maybe the member of legal aid society comes, because as you might be aware that as we have the stage of poverty that where we are, or the stage of illiteracy where we are, especially in the law field, or maybe the stage where the people are, how much they are aware about the law, but they have a lot of problems. So in that scenario, as a legal aid member or a member of legal aid society, where you can contribute that to aware them, to make them aware about their rights, and that itself is access to justice. It is not always that go to the court and ask for your challenges, but when you have the knowledge about your right, there and there itself you can question, there and there itself you can contradict whatever is not right, whatever is not correct, and then there itself you can get whatever what is of your benefit and what is of your within your particular boundary of your right. So this access to justice is a constitutional, the role of law schools that we are taking a part of as a legal aid society. Even there are legal aid clinics which are also run and which is mandatory, has to be run by the law schools, and that is what the duty that we have as a law student. Then as we have seen, looking at the population, the number of population that we have, the number of lawyers that we have, even that is very imbalanced. That also leads to the somewhere inability to get the access to justice. Then looking at the cultural barriers that we have, somewhere that also leads to sometimes challenging to get the access to justice. And certain geographical complexity and having the limited knowledge and resources and also awareness about the law, awareness about the existing rights, even that leads to the further challenges. So therefore, when we are part of as a law student, it is not only to become an advocate, but also to see that whoever is unaware about their rights, whoever is unaware about their duties, whoever is unaware about their duty, maybe as a government official or maybe as an individual, then as a law student it is our duty that we should make them aware about the same. Next one. So in the constitution, as we have this article 39A, which is the constitutional directive that we have for the free legal aid, ensuring the justice on equal footing for all the citizens, as this article 39A which was inserted in the constitution by the 42nd constitutional amendment. And through that, basically once it becomes a constitution or constitutional provisions, then that further led to have this Legal Services Authorities Act 1987. So whatever the legal aid clinic we have, whatever the legal aid societies we have, or whatever the legal work that you are supposed to do as a member of legal aid society, all this is not only just as an activity that you are doing as a law student, but it is also equally a mandate of law. So what you are doing as a member of legal aid society, it is not just you are getting an exposure, okay, but it is also somewhere you are performing your role as a PLVs, as sir has mentioned, paralegal volunteer, or as a member of legal aid society. So Legal Services Authorities Act, it basically mandates the law schools, all the law schools, that they should have some mechanism wherein they can, the law students can contribute in the existing legal system and also the existing challenges that we are facing. Therefore, Legal Services Authorities Act has institutionalized the legal aid through multi-tiered network, that is NALSA, then state, district and taluka levels. So national level legal service authority that we have at the central level, at the state level, district level, and recently they have been incorporated at the taluka level also, because if it is at the central level and only at the state level or district level, that is not basically dealing with all the problems. ये जो तीन layer हमारे पास है भी, but they are not basically resolving all the problems. So even we should have at the taluka level also, so wherein the some local language people or wherein the local knowledge जिनको है वो अच्छी तरह से उनको एक cooperate कर पाए, ठीक है? And there is two sections are very important. If you open the Legal Service Authorities Act, then we have these two sections, that is section 12 and section 13, which are very important because that is something which is helpful for us in our daily work that we are supposed to do as a member of legal aid committee. Next. Then here I am just referring 2-3 more points here, which is legally very important because it is not just a part of activity as I mentioned, it is also a legal mandate. And even the BCI, the Bar Council of India, also set up certain legal education specifically for the functioning that you are doing as a member of legal aid society. Then we will also see now certain roles that are supposed to be played by the state or the district or even along with them some NGOs for the providing the legal aid. Now here, when we talk about this institutional mechanism and especially the institutional mechanism which we have, that is National Legal Service Authority or even the State Legal Service Authority or District Service Legal Authority, they have to perform certain mandatory functions. And these mandatory functions are somewhere obviously to assist the people who are needy, the people who are not able to get their justice. And therefore this NALSA regulations basically mandates that the supervisory authorities at the different levels should regularly review and monitor the functioning of legal aid clinics which is run by the law colleges. So when in the law college, if you have a legal aid committee, if you have this legal aid clinic, so this is not only supposed to be run by the colleges just as an activity, but it is also a mandate that has been made by the Act. And even the NALSA or state or district, they will also keep a check on every law colleges that how much work they have assigned, how much work they have achieved, how much contribution they have done, because we have several examples that you might get from the internet also, some sources also, wherein in the last year, that is in the year October 2024, if you see the documentation that is made by the Supreme Court of India, and that documentation is specifically focusing on the work that has been done by legal aid committees of different law schools. Law schools जितने हैं हमारे इंडिया में, उनमें से उन्होंने सर्वे करके ये पता किया कि what every law school has contributed as a legal aid clinic for the according to this Legal Services Authorities Act, and that contribution also has been it is a part of the Supreme Court library also, and in that document also you will find that what law school have achieved at their different stages, and that has been not only done by the law school, but ultimately there is a contribution of students like you only. Because students who have worked day and night for that particular mission, and they have ultimately become benefited for that school or for that college and for the students as well. So wherein that kind of work that you are doing, it is not just a part of activity, but you are somewhere, it is when you talk about legal education. Legal education तो हम ले ही रहे class में, like we know different laws, we know different provisions, we know the sections, we know the principles. So ultimately what we are learning in the classroom, हम क्लास में क्या पढ़ रहे हैं? हम क्लास में ये पढ़ रहे हैं that what should be the ideal law. एक ideal law कैसा होता है? What are the provisions of law? What is the ingredients of law? What are the standard cases? But that is just theoretically that we are learning. But ultimately after 5 years or 3 years of course, when we are entering into the field, then we should know what is exactly happening in the field, what is exactly happening in the existing like society. That means that when you from such societies, maybe Woodford society or maybe legal aid society, when you become a part of the society, here you are not only learning about the law, but here you are experiencing the law. Because that is what the main difference we have. Because learning the law from classroom and learning the law from society, both are having very different perspective. And that perspective that you can build by experiencing the law on the field, in the society. When you will go in the society, maybe through some visits, अगर आप एक visit करेंगे, maybe some slum area हो या कोई National Human Rights Commission हो या कोई mediation center हो, then again you have DLS service, these authorities ho. So if you visit different places, then you will learn different things. Maybe some jail visits ho, there also you can learn so many things. So therefore NALSA have made this rule that every different level stakeholders at the district state level, they will have the supervisory functions over the legal aid training that is done by the different law colleges. Then particularly like DLSA, that is Delhi Legal Service Authority, must also collect monthly reports from the legal aid clinics under their jurisdiction, including those law colleges and the universities. And further, state, and they must also issue the direction from time to time to improve the clinic services or to the weaker sections of the society. So even the DLSA or the state legal service authority, even they do have a power after having the understanding the work what they are doing, then they can also provide some more suggestions. And furthermore, the state legal service authorities are required to send quarterly reports on the functioning of clinics to NALSA. So the district level या state level पे जो schools और colleges में जैसे legal aid clinic run कर रहे हैं, उनकी report NALSA को भेजना mandatory है. Therefore, this part also we should understand that it is not just a mandate that we are supposed to do as an activity, but further it is ultimately that we should contribute meaningfully, we should participate meaningfully towards this mission of legal aid. Next. So in the institutional framework, as I mentioned, we have like 4 important institutions under this Legal Service Authorities Act, and wherein as a PLVs, that is paralegal volunteer, this term probably you have heard, and you may be the part, some of you may be the part of this or may become part of this paralegal volunteer, wherein you can actually contribute to these institutions as a law student. Being a law student, it is not necessarily that after becoming an advocate you have to wait for this, but being a law student, you can actually contribute to certain legal problems which are right now present. Maybe it may be from prison, it may be from some woman issue, child issue, maybe some other social issue. So as a law student, you can right now also you can start contributing to resolving those legal problems. That is what the power also you have as a law student. So this NALSA is the highest body that we have, and this is the highest, that is central level body that we have at the central level, which is established under this. Then it works in coordination with different authorities. Similarly, the SALSA, again at the state level, and this SALSA is also like State Legal Service Authority, also responsible for what? It is responsible for to make sure that whatever the NALSA is basically declaring, that is National Legal Service Authority making some declaration or bringing some new policies, bringing some new rules that should be implemented properly. And each SALSA, again headed by the Chief Justice of the respective state high courts, who serves as the patron in chief. So we also should remember that when we talk about NALSA or SALSA, then this has been headed by the Chief Justice, again the Supreme Court judge, that is when it comes to NALSA. Then if it is state level, again it is the High Court judge, and again Chief Justice of High Court being the patron in chief. So somewhere the work that you are also contributing, and again through the direction of these judges, so somewhere you are creating a direct impact. So when we talk about the access to justice and strengthening the role, so as a law student, you also have certain responsibility that you can contribute meaningfully to resolve certain problems. The next one we have that is DLS, that is district, and then Taluka Legal Services Committee has been recently introduced in the this Legal Service Authority Act, and wherein it operates at the Taluka level or Mandal levels, and which is very smaller and more localized administrative unit within the district. As in the district, we have different talukas. So at the taluka level, considering the population, considering the strength or problems that they have, so even taluka level, certain district legal services committee have been established, and that basically contributing for the legal aid. Next, there is also another category that we have, a Lok Adalat. You must have heard about this Lok Adalat, and some of you might have also visited the Lok Adalat trials or Lok Adalat hearings, which is also a new mechanism that we have, because it is a part of this alternative dispute resolution, right? So instead of resolving the dispute with the complex legal procedure that we have in the court or before the judge or in the judiciary, this Lok Adalat is something that we have, which wherein you can resolve the disputes in a such a way that alternatively outside court you can get certain settlement. So it is a forum of alternative dispute resolution, and it is a people's court wherein disputes are settled amicably without the need for any lengthy court proceedings. And what type of cases that Lok Adalat can handle? It is any civil case and the criminal cases which are criminal cases which are compoundable offences, like compoundable criminal cases can be handled by Lok Adalat. Next, here just one thing I would like to highlight, that we have this concept of permanent Lok Adalat as well. Some of you might be aware. So we just know the differences between what is Lok Adalat and what is permanent Lok Adalat. Okay, so first type of difference that we have, Lok Adalat is something that is temporarily organized at the intervals, and the permanent Lok Adalat that we have is the permanent body established under the Legal Services Authorities Act. It is permanently set up. Lok Adalat it may be gradually come after some interval, but permanent Lok Adalat is permanently settled, and even the decision of this permanent Lok Adalat also has certain values. Then jurisdiction can handle cases that is pending in the court or pre-litigation cases, wherein the permanent Lok Adalat primarily handles the pre-litigation cases, wherein the public utility services such as transport, postal and telegraph services. So it is permanent Lok Adalat, rather than going after the decision, it basically tries to resolve the dispute in the pre-litigation stage itself. So once the dispute is resolved in the permanent Lok Adalat, in the pre-litigation stage, then there is no scope again to go for the same matter in the रेगुलर सिविल कोर्ट और रेगुलर सिविल सूट. तो परमानेंट लोक अदालत का जो डिसीजन आएगा वो फाइनल रहेगा, उसके बाद आप उसको दोबारा चैलेंज नहीं कर सकते टू द रेगुलर सिविल सूट, एंड इट इज समवेयर आल्सो असिस्टिंग दी और बेसिकली रिड्यूसिंग द बर्डन ऑफ द कोर्ट. Then composition is the bench of conciliators, wherein there are chairman and 2 members. Then further also decision making power. In the Lok Adalat cannot make a binding decision if no settlement is there. Then the case will again go back to the court. So in the Lok Adalat, that is what we have a possibility, but in permanent Lok Adalat they can issue the final judgment, and it is the binding award on both the parties, and if the parties fails to agree. Then pecuniary jurisdiction, in Lok Adalat no specific upper limit. In permanent Lok Adalat there is a jurisdiction that is limited on the specific monetary value. And the purpose of both these institutions is very different, that to resolve the dispute through the compromise and mutual agreement, but here to provide the mandatory litigation mechanism for conciliation and settlement of public utility services disputes only. Okay. Next. Now the most important part, I think, who are part of this legal aid committee, they should also aware about this under the section 12. That who is entitled to this free legal service. So this word entitled, that's why I mentioned in the beginning, that this free legal services is not available to everyone. So when you say that legal aid as a fundamental right, legal aid or free legal aid as a fundamental right, then there we are talking about the aid. That means you are giving some help, you are giving some advice, you are just giving the knowledge that how to proceed further. But here what we are talking about, who is entitled to the free legal services. So that services includes everything. मतलब अगर आप किसी आपके पास कोई प्रॉब्लम लेके आता है क्लाइंट, right? Or maybe some person who is a victim. So if victim comes to you, so from reaching that person to you till the end of the decision, everything has to be free. That is what the free legal service here we are talking about. And here there are people who are only entitled, people only can come under this particular section. Who are these people? This section 12 basically talks about the different categories of people. So the people who member of the scheduled caste or scheduled tribe, or the victims of trafficking, or woman or child, all category of like these without any financial or in any kind of restrictions. So all women, children, then mentally ill or otherwise a disabled person, like physically challenged person, even that person will have entitled to have the free legal services. Then the people who have circumstantial challenges they might have faced, maybe the victim of disaster, then victims of this ethnic violence, caste atrocity, flood, earthquake, industrial disaster. So even such kind of people also are eligible to get the free legal services throughout the process. So there is no need to pay any kind of money during this process. So that is what the difference that I wanted to highlight, that having the legal aid and having the legal services, both are quite different things. So when you talk about the legal aid, so in the before the legal aid committee or before the legal lawyer, you may get aid, you may get advice, but the entire services you might have to pay if you are not under this particular section, if you don't fit under this section. Therefore, free legal services are available only to the people who are entitled. I just wanted to emphasize this again. Then the people who are in the custody, like there are certain under trial prisoners, so again they probably might face this help of this free legal services. Then we have juveniles, then we have people who are having the specific annual income, like in various districts, various states, that amount may vary from time to time, that up to what kind of people like income they have. So below like 4 lakh, like if they have annual income of 4 lakh rupees, so below that everyone is like possibly come under this free legal services, but beyond that they may not come under this free legal services, and that amount will every time it will be revised, it will be changed by the NALSA or maybe by the authorities of the legal service authority. So this entitlement you have to remember very carefully. Next. Okay, so some of you might have visited the NALSA website. Have you seen the NALSA website? And if you see the NALSA website, then I just wanted to highlight as the knowledge, I think a law student that you should also know that how this website basically can be displayed and how easily it has been kept for everyone who wish to know, as a law student maybe, or if you want to guide someone, that if you want to file a complaint, then how you can raise your complaint here. So here, as you can see, there is a apply the legal aid, there is a clear section that we have, then track your application, then reminders, clarification that we have. So these are certain simple things that has been kept just for everyone, because those who do not have a knowledge, but if someone is in problem, then they may not get any solution immediately. But the people like you, if you know the solution, if you know that how to guide them, then this is what easily that we have. And here also they have provided video also, some demos, how it basically you can file your complaint. And also this part is again there, that who is entitled. So who is entitled? Like जब आप अप्लाई करने जाएंगे, person is victim, but हर कोई victim होता है अलग-अलग तरीके से, but हर victim को हम solve नहीं कर रहे यहाँ पे, right? But victim who is entitled, who have some violation of some rights, violation of some interest, violation of some legal rights, that person can come under this. So who is entitled also they have highlighted here. And procedure after filing. So once you file a complaint, raise your complaint, then what is the procedure that we have after filing the complaint? Even that has been mentioned in this particular page. So this structure that we have, that is of NALSA page or NALSA website and how to file a complaint. Similarly, we have for the state and also for the state. Next. And here, this part I wanted to highlight is that the NALSA, some of you might have aware that what type of scheme that they have introduced, any idea? Recently, like from last 5-6 years, what type of schemes that have been introduced by the NALSA, any idea? Have you come across any new schemes that they have been introduced, that NALSA have been introduced for the betterment of this? No, legal aid services that they are providing. Which idea hai aapko? Like what new schemes that they have introduced? There is a one scheme that is called as Tele Law. Tele Law, T-E-L-E. Here you can see it. Or by visiting the Common Service Center, or maybe you can call the helpline number. There is a helpline number that we have, like 1446454. So this helpline number also we have. So this three options that you will have. Then that will further goes, if it is through the app, it will go through the SMS. The appointment will, you will get an SMS that your appointment is booked or you have your consent has been noticed. Then there will be either video consultation, even video consultation facility is there nowadays, and also the consult a lawyer through the video conference or on a call on the scheduled date and time. So this facility is also provided by the this tele lawyer and by the centers. Then further, after that the legal advice by the panel lawyer rendered, then lead lawyer for the representation in the court, then it will forward it to the other new branches that has been introduced like Nyaya Bandhu. You must have heard this term Nyaya Bandhu, which is also recently introduced by the Supreme Court of India, and through that Nyaya Bandhu, you can say umbrella, they have introduced the pro bono legal services. Pro bono legal services. So pro bono legal service is again a duty as a lawyer that we have to contribute, and we have to contribute for the free legal aid. And then if there is a matter is not solved, then it will go to the Nyaya Bandhu. If it is solved, then beneficiary is already served, because here legal advice is provided, here there is a video consultation by the lawyer. If here itself matter is resolved, then the beneficiary is served. If not, then again it will forward to the Nyaya Bandhu. And again the Nyaya Bandhu registration, then again consultation, again final representation in the court. So this structure that is already been provided on the website, and this is something that even easily can be understood by the anyone. Next. So these are basically two. I thought that you can also see the demo, basically that how the complaint can be filed. So there is an application form. If you can just open the application form, you can just click on the first link. हो सकता है? Open हो रहा है? They are not download. Can you just try to open this copy and open this form? This answer, where there is a clear-cut form that we have application form for the legal aid or devices, and this form is available in the different languages. So when there is this Legal Service Authority Act is enacted, it is not only for the people who are having the knowledge about everything, but even it is available in the local language. You can just take down a little bit, scroll the page. Then you can see this application has to be filled carefully. So application for what purpose, there are different purposes are there, and under what category that it will go. So you also need to, basically when you apply for this, then you should also have to submit an affidavit. आपको एक affidavit देना होगा which basically prove or which basically justify that as a victim or as a victim of some problem, then whether you are really entitled to get the free legal services or not. जो entitlement के लिए जो आप claim करेंगे. So for that purpose you have to submit an affidavit. So it is not only that form that you have to fill up, but also you have to submit the affidavit that you have to make sure, you have to assure that you are entitled to get the free legal services under this particular act. This application form have to fill all the personal details, all the clear details of different category, and at the end that you will be able to access the justice. The next, you can just, the form is basically last option we have where you have to submit your attach the documents. That is something that is affidavit, which is very mandatory. Without affidavit, you cannot go further. So affidavit at the initial stage, the Department of Justice, the Ministry of Law and Justice, they have already introduced that how this app has to be accessed. Yes. This video is just showing you that how this Telega app can be downloaded and how as an applicant, how as an advocate, one can access to this particular app. It is a scheme introduced by the Ministry of Law and Justice itself. So as a law student that we should be aware. हमें नहीं पता होगा तो हम client को क्या बताएंगे और कहाँ guide करेंगे. So especially as a member of legal aid society also you should be aware about this. Why this app is introduced. The core is that you can reach out to the people, you can reach out to their problems, you can solve their problems. तो जैसे आजकल हमारा जैसे स्विगी जोमेटो जैसे आजकल हो रहा है ना सारा स्विगी या ऑनलाइन जैसे आ चुका है, इट इज मोर एक्सेसिबल. जब भी भूख लगी ऑनलाइन ऑर्डर कर लिया. अदरवाइज पहले गाड़ी निकालो, होटल जाओ, ऑर्डर करो, तब तक तो बड़ा टाइम लगता है. बट मोर एक्सेसिबल, मोर बिजनेस. दैट इज व्हाट इन द बिजनेस पॉइंट ऑफ व्यू. बट व्हेन यू टॉक अबाउट लीगल एड पॉइंट ऑफ व्यू, the more accessibility if you have to the app, to the video or through the some kind of schemes, it is more beneficial for you. Okay, so these are certain innovative legal aid schemes that we have, and as a law student you can take the benefit of this platform. Next. Then here as I mentioned that as a law student also you can contribute to it, wherein the being a more aware about the legal aid schemes or the legal aid provisions. The after hours legal aid clinics that we have, certain mandatory curriculum, even the BCI, that is Bar Council of India, जिसके अंडर हम लॉ कॉलेज चलाते हैं, जिसके हम लॉ स्टूडेंट्स हैं, जिसके रूल के हिसाब से हम अपना अटेंडेंस वगैरह कंपलसरी फॉलो करते हैं, राइट. सो उसी बार काउंसिल ने ये मैंडेट किया हुआ है कि क्लिनिकल लीगल एजुकेशन हैज टू बी अ कंपलसरी सब्जेक्ट. So everybody should have the practical knowledge, practical visits, and which is something which is very mandatory for every law student. Okay, next. And the paralegal volunteer, I think you are aware that this paralegal volunteer is not only students of law, but they are actually contributing to the litigation. They are actually contributing to the. Okay, please. They are actually contributing to the litigation. Okay, all these are volunteers of legal aid committee. Right? Most of you may be the volunteers of legal aid committee, right? So when you call it as a volunteer of legal aid committee, then volunteer. Okay, so when it is a volunteer, that means voluntarily you are contributing. You are contributing in such a sense wherein there is no return that you are expecting, but you are giving your 100% to that problem or to that. To bring that problem into some solution. Okay, so paralegal volunteers, it is like opportunity for a law student that they can get the practical knowledge, they can get the experience of the actual problem that is there in the society. So once you graduate from the law, then it is easy for you to access everything. It is easy for you that you know that certain things are already existing in this manner. And now it is how that your plan of action should be. It is also easy for the lawyer, because otherwise if you simply study the ideal law from the classroom, then there is no point that after 5 years you will see that कि भाई books में कुछ और था और बाहर कुछ और है. Like in reality there is something else, in the books what we have studied it is something else. So, but being a paralegal volunteer, you have a good opportunity to have this, to promote this legal literacy, also to handle this mediation and dispute resolution problems, or you can say the mediation or dispute resolution patterns, that how to do this mediation schemes, alternative dispute resolution schemes, and also to facilitate the access to justice. And the community outreach, I hope that if you probably have visited some of the different areas, maybe the prisons, maybe the slum area, where you have probably have understood that how this community outreach is important, because ultimately you are basically communicating with the people who are not aware about the law. The next services program, which has been initiated by the Department of Justice, and this program has basically achieved some goals which they supposed to achieve or which they have expected to achieve. And these goals are that obviously to get better access to justice. So when you talk about access to justice, so जितना efficiently हम access to justice को achieve करेंगे, उतना ही बेहतर होगा. Next, so the last part that we have is about the certain challenges, and those challenges about what, that having all these schemes, still there are certain things are lacking, and for that digital reach, strategic alliances, then local outreach and volunteer integration. So ultimately, that whatever the laws that we have, whatever the schemes that we have, it should reach to the right people, it should reach to the needy people, it should reach to the people who are not aware about the law, and they should get aware about the same. And even we have this Telelaw app, but looking at the infrastructure, looking at the financial challenge that people may have, they may not able to get the access to these schemes. So as a volunteers, that as a law student, that we should assist, we should help that who are having these problems. And next, so here as a law student, we can also have some kind of target that our commitment to more towards the pragmatic approach, to having the engagement when it comes to the such legal services that we can provide to them. Then we can also make the effective use of technology. So like nowadays we are in the era of this Instagram, Facebook or whatnot that will come in future, and also the AI, that is artificial intelligence. So we are in that era. So we know that how that AI is basically transforming the generation and also the knowledge. But at the same time, it can also be taken in a positive way, wherein with the help of AI, whoever is interested, they can also make certain videos which can give the idea about certain legal process. Like if it is how to file a complaint, like if there is some problem is there, maybe about some serious concern about some any severe harm, or any if there is a license, it has to be renewed, right? Any caste certificate has to be issued. So इस प्रकार की अगर जो चीजें होती है, इसके बारे में आप AI की हेल्प से वीडियो भी बना सकते हैं, which is also ultimately you are making it better to have an access to justice, right? मुझे अगर इसको कास्ट सर्टिफिकेट निकलवाना है, पता नहीं कैसे अप्लाई करना है, but with the help of social media and with the help of technology knowledge that you have, अभी आप next version है आप सारे advanced technology में, तो आपको AI ज़्यादा पता है how to use and how to misuse both ways. So if you can use it for better way, so obviously this is nothing but you are helping for the access to justice. Somewhere use of technology in the right perspective also can be helpful. Then last few we have, so you probably must have heard about the this Roscoe who talk about the social engineering, right? But somewhere as a lawyer we are also social agents, where we are representing the principle, that is the people who are in need, who are in the problem. So as an agent we also have certain responsibility. It is not, and also we can be a helpful resource to help such people who are of need, who are having some concerns. And capacity building or some arranging some conference, seminars, replay, AI videos, local languages, and many more other contribution can be done as a law student. Right? So local language में वीडियो अपना एक अलग contribution हो सकता है. ठीक है. And also probably whenever you might have visited different prisons, different slum areas, then one thing that you should also remember is that मतलब as a trip के लिए नहीं जा रहे हैं, अगर कहीं हम विजिट के लिए जाते हैं कई बार होता है ना माइंड सेट कल विजिट के लिए जाना है तो बस एक घूम के आता है, जेल देखना एक्साइटमेंट रहती है. बट हियर यू शुड ऑल्सो लर्न, यू शुड ऑल्सो मेक सर्टन प्लान्स अबाउट व्हाट. अगर आप जिस विजिट के लिए जहाँ पे भी आप जा रहे हो देयर उसकी एक पहले से आपको एक थोड़ी अंडरस्टैंडिंग होनी चाहिए, लेकिन व्हाट प्रिजन दैट यू आर विजिटिंग, what is the capacity of that prison, what are the issues that prison has, what are the challenges that prison is facing, what are the legal, like the prisoners, if there are prisoners, what are the legal issues that they are facing. So इसका कोई data available पहले है क्या? Some theoretical study that you should do, and after doing that theoretical study, when you do the visit, that will be much more better. That will be very effective visit that you will have, because there you can raise the questions. So this is the data says और आपके practically में ये ऐसे हो रहा है, then what kind of solution that you are bringing to this, so even that is more effective for you. Therefore whenever you are visiting the NHRC or any mediation center or any prison, so there you should do some brief study, you should do some brief research about that particular area or any institution, and then you probably visit, and that will give you more confidence also, because there you can't just sit like this कि भाई घूमने आए थे, but ऐसा नहीं कि आप वहाँ जाके आप authorities को question भी कर सकते हैं. Sir, your website, your data, your research is talking about this kind of data, then what is the solution that you have done, what kind of mechanism that you are doing, what kind of alternative that you are bringing to resolve such problems. और शायद आपसे भी कुछ contribution हो तो जाए, like to resolve this particular problem, you want to suggest something, even that can be done, because visit is not only for the purpose of looking at the building or looking at the photo खिंचवाने के लिए तो नहीं जा रहे हैं, but also to learn something, so that you can get benefited about that institution, from that institution, and you can also learn and contribute. Okay. So these are few things that we have, and apart from this, if you have any question, you can please ask. अगर क्वेश्चन है आप पूछ सकते हैं, ठीक है, या कुछ नहीं समझ में आया तो बता सकते हैं.
To formally close, I request Dr. Sonawane ma'am to deliver the vote of thanks. Good afternoon, everyone. We extend our heartfelt gratitude to Dr. Ajay Sonawane, Faculty of Law and member of Legal Aid Clinic, or we can say the cell of the University of Delhi, for graciously accepting our invitation to be the resource person for the Legal Aid Clinic, Vaarta, interactive session on strengthening access to justice through legal aid, innovation challenges, and the role of law students. We are particularly thankful to Dr. Sonawane's initiative in bringing along with his esteemed colleague, Dr. Ajay Sharma, Senior Assistant Professor, Faculty of Law, University of Delhi. Their combined expertise and insights will undoubtedly enrich the interactive session and provide valuable learning experiences of our law students. Their contributions will play a significant role in enhancing our students' understanding of legal aid and its importance in the justice system. We appreciate their dedication to sharing knowledge and empowering the next generation of legal professionals. Thank you once again for your support and cooperation, sir. Thank you.